Understanding mental injury claims. Today we're talking about how to make a claim for a mental injury in a personal injury action, how to prove it, what goes into that, and two important cases that you should be aware of just to know what constitutes a solid mental injury claim. I'm Natalie Gary, the principal lawyer and founder of Gary Law. I help injured people get the compensation that they deserve for their injury. Let's get into this topic today. In law, when we want to know how to build a solid lawsuit, we look to case law and how that has turned out for people in the courts. In 2017, there was a very important Supreme Court of Canada case about mental injury. It's called Saadati and Moorhead, and it set a precedent for what constitutes a compensable, so a claim that you can recover money for in terms of mental injury, and the type of evidence needed to prove this injury. Recently, the Court of Appeal has also revisited these principles in a case called Bothwell and London Health Sciences Centre, and this case clarifies the criteria for compensable mental injury. So let's talk about this Saadati case. In 2017, the court rendered its decision, and this case had a big impact on personal injury claims, especially those involving psychological injuries. What was this case about? So Mr. Saadati was involved in a series of motor vehicle accidents between 2003 and 2009. So over the course of 6 years, he was then, after the last one, he was declared to be mentally incompetent. This case, the Saadati case, focuses on an accident from 2005 where Mr. Saadati's truck was hit by a Hummer that was driven by Mr. Moorhead, the defendant. Mr. Saadati started his legal action after a third accident, and he was seeking compensation for non-pecuniary damages, so those are those pain and suffering damages, as well as past income loss. At the trial level, the court did award Mr. Saadati $100,000 for mental injury based on the testimony of his family and friends. The defendants appealed this decision, and the Court of Appeal agreed with the defendants and overturned the decision. They questioned the validity of awarding damages without a medical diagnosis of a recognized psychiatric illness. So Mr. Saadati then appealed. He wanted to continue to argue that he did have a recognizable illness and that he was entitled to damages. So he went to the Supreme Court of Canada. At the Supreme Court, they decided that the psychological injuries could be compensated without expert medical evidence or a recognized psychiatric condition. The Supreme Court agreed with Mr. Saadati. They emphasized that there shouldn't be a different standard for proving mental injuries compared to physical injuries. The court pointed out that mental and physical injuries should be treated equally under the law. This ruling clarified that you don't need a specific psychiatric diagnosis to claim damages for psychological injuries. Instead, it's enough to show through evidence like testimony from family and friends that the injury is real and serious. So the key takeaways from the Saadati case are the Supreme Court highlighted the equal treatment that is deserved under the law of mental injuries and as compared to physical injuries when it comes to compensation. So there's no need for a distinct set of rules for proving psychological harm. The Supreme Court also showed the flexibility of evidence in that you don't necessarily need expert testimony to prove a psychological injury, that the testimony from family and friends was sufficient in this case to demonstrate that Mr. Saadati had suffered a serious and prolonged mental disturbance. This case also highlighted that it wasn't necessary in the case for a recognized psychiatric illness to be diagnosed. The focus is more on the substance of the injury, not on the label. So this case was a significant step forward in in recognizing the validity of psychological injuries in personal injury claims. It ensures that individuals who suffer mental harm due to someone else's negligence can seek compensation even if there is no formal diagnosis of like depression or PTSD. In looking at the more recent Court of Appeal case, Bothwell and London Health Sciences Centre, the Ontario Court of Appeal sort of refined what can qualify as a mental injury, and they gave some more criteria for how to assess it and how the case has to be built. So in looking at Bothwell and London Health Sciences Centre, in that case, the plaintiff, Mr. Bothwell, experienced a critical medical error when he was recovering in hospital. His blood pressure dropped and a nurse accidentally gave him a blood thinner instead of a blood volumizer, as was ordered by the doctor. The error caused Mr. Bothwell to black out, and when he regained consciousness, he felt short of breath, he was very hot, and he had to eventually be sedated and intubated. So it was a serious occurrence. Mr. Bothwell was also a paramedic and was well acquainted with these medications, such that he was really aware of what happened and the error, and this was particularly distressing to him. This led him to sue the hospital and the nurse for medical negligence, and he was citing psychological harm. That's what he was claiming for. At trial, the judge ruled in favor of Mr. Bothwell and determined that his psychological upset was objectively and subjectively serious enough to constitute a mental injury. The defendant hospital did appeal, though, and they argued that Mr. Bothwell's anger and frustration over the medication error was insufficient to establish a compensable mental injury. So the Court of Appeal reviewed the case. They applied the principles outlined in the Saadati case, and the key points that they considered were that the mental injury was not proven by the existence of mere psychological upset. They said that the severity and duration had to be prolonged, serious, and had to exceed ordinary annoyances, anxieties, and fears. The court said that the degree of disturbance that the claimant has to show must be significant. They also said that the impairment of functions must be an impairment that is significant enough to affect the cognitive functions and daily activities of the plaintiff. The court also looked at evidence flexibility, and while a psychiatric diagnosis is helpful, they acknowledge that it's not required and other evidence can suffice to prove mental injury on a balance of probabilities. In Bothwell's case, though, the Court of Appeal found that the trial judge had failed to adequately consider the degree of disturbance Mr. Bothwell experienced. The Court of Appeal noted a lack of evidence showing impairment of his cognitive functions or daily activities, and the Court of Appeal found that there was no evidence of treatment for his anger or frustration. The appeal record also indicated that Mr. Bothwell continued his work as a paramedic. He maintained his roles as a father and husband without significant disruption. So the takeaways from this case are that it is very important to have solid evidence. Even though Saadati clarified that expert medical evidence is not necessary to prove a mental injury, claimants who do not provide relevant medical evidence do risk having their claims dismissed. This case also underscores that the harm has to go beyond emotions. So feelings of anger and frustration alone are considered psychological upset, and they do not rise to the level that's required for a personal injury claim in Ontario. There must be clear evidence of a serious and prolonged impact on the claimant's mental health and daily life. The court also emphasized a comprehensive assessment that they will closely examine how a psychological injury affects a claimant's cognitive functions and participation in daily activities, alongside with the nature and effectiveness of any treatments being received. So overall, the Court of Appeal's decision in Bothwell provides a clearer framework to understand mental injury claims. It emphasizes the need for substantial evidence to support claims of mental injury beyond mere psychological upset, and ensuring that only cases of serious mental injury are compensable in personal injury law. This ruling reinforces the principles established in Saadati and highlights the importance of thorough and compelling evidence in personal injury cases, especially those involving psychological harm. If someone you know, or if yourself, you've been affected by a situation similar to Mr. Saadati's, this ruling could be very relevant. You do need tailored legal advice to your situation. This decision underscores the importance of working with your lawyer to gather comprehensive evidence and testimony to support your case. If you have any further questions about this type of psychological or mental injury and you need further information, please feel free to reach out and I would be happy to discuss your case with you.